of the Division of U.S. Studies here at the Woodrow Wilson Center, and I'd like to welcome you to this discussion of presidential constitutionalism in perilous times by Scott Matheson, Jr., who's sitting to my right. Before introducing our speakers, let me just say a few words about the Wilson Center and its relationship to today's event. And in this, I'm following the tradition of Philippa Strum, the former director of U.S. Studies, who always had a few interesting things to say about the history of the Wilson Center before every event. The Wilson Center was, as many of you know, founded in 1968 as a living memorial to President Woodrow Wilson. And it was envisioned as a place where scholars and those involved in public policy and public affairs would come together to study and discuss issues facing the nation and the world. A place that would embody the spirit of Woodrow Wilson, who was himself first a scholar with a PhD in political science, then a professor of jurisprudence, then president of Princeton University before becoming our 28th president. How would President Wilson have responded to the discussion we're about to have? With his deep interest in jurisprudence, he would have immediately grasped the intellectual dimensions of the subject that Professor Matheson treats in his important book. For, as Professor Matheson writes, quote, "No modern president had more developed views on the executive's role in domestic and foreign policy than Wilson." But his views were not purely those of a scholar. They evolved over time in response to his own experience in grappling with difficult constitutional issues in perilous times, in his case, the Great War. Thus, the man who wrote in 1908 that agitation is certainly of the essence in a constitutional system, unquote, went on to assert in 1917, if there should be disloyalty, it will be dealt with a firm hand of stern repression. As Professor Matheson puts it succinctly in his book, the Wilson of Princeton was not the Wilson of the White House. The question of presidential power is one that challenged not only President Wilson, but several of his successors. And it certainly came to the fore in the last administration and continues to vex the presidency today. Indeed, Scott Matheson reminds us, the issue of executive power in times of emergency and its attendant tensions and controversies will always be with us. Under what conditions should it be allowed to grow? To what extent does national security allow or compel a chief executive to limit individual rights? Does the Constitution countenance or forbid suspension of personal liberty in a time of crisis? Our discussion of Professor Matheson's book will allow us to gain some perspective on these and other quandaries by stepping back from the politics of the immediate situation to consider how these issues have played out within the broader context of American legal, military, and presidential history. We're fortunate to have with us today the author of this important book and as commentator, a leading professor of national security law. You have detailed bios of our two speakers on your handouts, so I won't provide full introductions. But let me just say briefly that Scott Matheson, Jr. is the professor of law at the University of Utah, and he completed much of the work for this book as a public policy scholar here at the Wilson Center in 2006-07. Our commentator, Harvey Rishikoff, is currently professor of national security law at the National War University's National War College here in D.C., and he has a forthcoming book entitled The National Security Enterprise, Culture and Bureaucracy. Our format will be as follows. Professor Matheson will introduce his book, Professor Rishikoff will offer a comment, and then we'll open the floor for discussion. Afterwards, you're all invited to a reception in the lobby outside, where copies of the book will also be available for sale, and I'm sure Professor Matheson will be happy to sign them. Welcome.
Well, thank you very much, Sonia, and it's a great pleasure to be here with all of you this afternoon. Special thanks to Sonia. She is not even starting her job as director of the U.S. Studies program here until next week. So she has already planned and participated this program and is obviously off to a great start. Also thanks to Susan Nugent, who is a long-term fixture of the Wilson Center, who made many of the arrangements for this program to be possible. And as it turns out, she's retiring next week. So we have coming and going surrounding this program. For those of you in the room who work at or are affiliated in some manner with the Wilson Center, you know how special this place truly is. But I want to say how how special this place is. I had the opportunity to spend some significant time here working at the facility, getting to know the people, having young people help me. I think my research assistants when I was here will join us at some point today. I want to acknowledge them, Marty Quadar and Brian Cruz. It truly is a wonderful research institution and has taken its place at the highest levels of research institutions in this country. In no small part, of course, due to the extraordinary leadership of Lee Hamilton, Mike Van Dusen, and of course in the U.S. Studies program, longtime director who just stepped down, Flip Strum, and I wanted to acknowledge her support while I was here as well. Also Don, who is here with us as well from the Wilson Center. I'd also like to welcome, as I look around the room, I see numerous Utah expatriates who have settled in Washington, some of whom are graduates of the University of Utah College of Law, where I teach. I'm delighted to see you here with us today. In fact, there's even a few people who were members of my book club in Salt Lake City who have come here, and so we'll call this a book club meeting this afternoon. Also, I'd like to acknowledge a number of individuals here from the law firm of Williams and Connolly, where I cut my teeth as a young lawyer and really learned what it meant to work hard at the highest levels of professional work and with some of the best lawyers in the country. So I'm glad to see some of my former colleagues here with us this afternoon. Well, a few weeks ago, I did a similar presentation, and at that point it was billed as a reading. And I'm going to make to you the same promise I made to them, which is that I won't read any of the 1,114 footnotes contained in this book. And I also promised that I would avoid all parts of it that sounded anything like a law review article, which unfortunately doesn't leave all that much, but we'll take what we can get as far as that goes. I'd just like to begin with how this project all started. I've been involved in studying, teaching, and writing about constitutional law for almost 30 years. And I've spent a lot of time thinking about how the framers tried to design American constitutional government to protect individual liberties. Much of this protection, of course, stems from the separation and sharing of powers in the Constitution, which, as you know, requires that for almost every significant governmental action, whether it's enacting a law, enforcing a law, appointing judges, or going to war, that at least two branches of the government have to be involved. Now, as we all became aware of some of the more significant decisions of the Bush administration to address terrorism, it seemed that the executive was acting outside that separation of powers framework and that our government was pursuing security at the expense of due process and individual liberties. And so we eventually learned that without telling Congress or the American people, the administration had decided that the president, as commander-in-chief, could overcome enacted federal law and international agreements that prevent torture. And we eventually learned that for years the Bush administration conducted secret electronic surveillance of American citizens in conflict with enacted federal law, the Foreign Intelligence Surveillance Act, again based on the president's executive power as commander-in-chief. In addition to these unilateral and secret actions, the Bush administration, as part of detaining enemy combatants, announced that the Geneva Conventions did not apply to them and proceeded to hold them indefinitely at Guantanamo and elsewhere without charge and without judicial review of their confinement. The president also created military courts without congressional approval and in conflict with enacted federal law. Recognizing that these extraordinary measures were taken when the president and our military were under enormous pressure to protect the nation from terrorism in a post-9/11 world, I was interested in reaching a better understanding of what the administration had done and, most importantly, how it compared with other presidents when they faced severe threats to our nation. And that takes me to the introduction of the book, which describes what this project was all about, where I write that the book examines executive power during national security crises. It's not about the power to initiate or declare war, but focuses instead on how the President and the executive branch address danger and respect individual liberty during war. It explores how in dangerous times the separation of powers and checks and balances affect the security-liberty balance. The analysis offered here reaffirms the primacy of the executive in responding to threats. It recognizes the important roles of Congress and the courts to check executive abuse and safeguard individual liberty, but it also emphasizes how much we must rely on presidential leadership and constitutional due diligence to ensure the Constitution's promise is redeemed in a system of separated and shared powers. So my book examines President Lincoln's suspension of habeas corpus during the Civil War before Congress could act, President Wilson's enforcement of the Espionage Act of 1917 to punish dissent during World War I, President Roosevelt's internment of West Coast Japanese during World War II, President Truman's seizure of the steel mills during the Korean War, and President Bush's torture, surveillance, and detention policies following the 9/11 attacks. The book's divided into three major parts. The first part discusses different constitutional perspectives on executive power. The second part applies those perspectives to episodes of aggressive use of executive power involving Presidents Lincoln, Wilson, Roosevelt, and Truman. And finally, the third part evaluates President George W. Bush's claims to executive power. Now I'm going to do something that some of us do sometimes, and we probably shouldn't, but I'm going to do it anyway with this book. I think I saw this in a movie somewhere where the protagonist was always going to the back of the book. But I'm going to skip to the part at the end that sets forth some of the conclusions, because I think if we go there, it might be helpful for you to know where I come out on some of the major issues addressed in the book. So, here's what we say at the end.
Scott, what page are you on?
I'm on 153. Each president pushed executive power in ways that burdened individual rights and crossed the constitutional line. None claimed the Constitution must be suspended during wartime, but all argued that wartime conditions allowed for less liberty protection under the Constitution. The Bush administration's justifications for and applications of certain security measures crossed into extra-constitutionalism. Lincoln argued that he was operating within the Constitution when he suspended habeas corpus the first time, pointing out that military exigency and the absence of Congress supported such temporary action until the legislature could meet. His administration lost the constitutional argument over trying civilians in military courts outside the theater of battle. Congress authorized and the Supreme Court affirmed the Wilson administration's prosecution of disloyal speech, even though the historical judgment is that the repression was arbitrary and violated the First Amendment. The West Coast Japanese evacuation program had retroactive legislative support and judicial affirmation, but it is now regarded as one of the nation's worst deprivations of liberty and due process. Truman exceeded executive power when he seized the steel mills, but he did not claim that the Korean War immunized his decision from congressional control. What made the Bush administration exceptional in this grouping was not the nature and degree of constitutional deprivations, which were serious but arguably less severe than in other wartime administrations. Indeed, Civil liberties expert Anthony Lewis declared in 2007 that Roosevelt's Japanese internment was very likely the greatest blow to constitutional rights in all the wars and times of stress in American history. Asking whether civil liberties suffered more or less under Bush than Lincoln, Wilson, and Roosevelt makes for an interesting debate about difficult and problematic comparisons. However, given Abu Ghraib and Bagram, warrantless wiretapping, and the host of detention issues, for example, extraordinary rendition, secret prisons, and indefinite confinement at Guantanamo, Bush is certainly among the presidents who have claimed significant wartime power and exercised it in constitutionally questionable fashion. What made the Bush administration exceptional was its extreme claims of unchecked unilateral presidential power. The administration's obsession with unilateral executive power was self-defeating. The torture, surveillance, and detention policies came under attack on many fronts, including the courts, the legislature, the press, and the public, isolating Bush in ways that weakened his ability to persuade and lead, the key component of presidential authority and effectiveness, under presidential scholar Richard Neustadt's classic thesis. Well, you'll all have to be the judge of whether the rest of the book succeeds in supporting these conclusions. What I'd like to do in the balance of this introductory comment is to give you some brief samples from the three parts of the book that I mentioned earlier, just to kind of set the stage for Harvey's comment and our discussion. As I said before, the first part discusses constitutional perspectives I use to evaluate presidential constitutionalism in perilous times, and begins with a discussion of the presidency in the original constitutional design, and points out that the framers wanted a single executive and a civilian commander-in-chief. They did not want a king. But the presidency was a brand new office, and the framing and ratification of the Constitution reflected uncertainty about how the executive would function and the scope of its powers. I won't take time now to explain the concepts developed in this first part, other than to identify a few attributes of executive constitutionalism, including the basing of government action as much as possible on the broadest basis of legitimacy, executive action authorized by Congress. It means sharing decisions with Congress, welcoming oversight and judicial review, and implementing processes within the executive branch that facilitate executive action within the law. That takes us to the second part of the book, which discusses various presidents and how they address security and liberty during wartime. No president has faced a greater threat to the survival of the nation than Abraham Lincoln. His wartime measures have been debated ever since, including whether they exceeded delegated presidential power and infringed individual liberties under the Constitution, and whether circumstances were so severe that action based on necessity was justified. Much of the debate centers on the critical 12 weeks between the fall of Fort Sumter on April 14, 1861, and the convening of Congress on July 4. During this period, Lincoln summoned the militia to active duty, increased the Army and Navy above authorized levels, called out volunteers for 3 years of service, spent unappropriated funds, suspended the writ of habeas corpus, arrested people suspected of disloyalty, and ordered a naval blockade of the southern ports, all without specific authorization from the Congress. He later explained to Congress that his emergency measures, as he said, whether strictly legal or not, were ventured upon under what appeared to be a popular demand and public necessity, trusting then as now that Congress would readily ratify them, which Congress ultimately did, although against the backdrop of Chief Justice Taney having ruled in the ex parte Merryman case that Lincoln's unilateral suspension of habeas corpus was unconstitutional, a ruling that Lincoln disregarded. The suspension of the writ and Lincoln's other actions are analyzed in the book under the various constitutional perspectives mentioned earlier. Here is a brief excerpt from the perspective of executive constitutionalism. Lincoln relied on a theory, page 47, Harvey. Lincoln relied on a theory that under the overriding pressure of rebellion, he could act to the extent of the federal government's powers, with the intent of seeking legislative support for actions that had to be taken before Congress could act. He implied that he ran the risk of Congress not backing him up, and in taking care that the laws be faithfully executed, he argued that he did what was possible to execute as many laws as he could, famously asserting that leaving one unexecuted is the responsible course when to do otherwise would leave the rest unexecuted. If full compliance were impossible, he chose the lesser of two evils. Lincoln's actions found support at the time in the idea of adequacy constitutionalism, that the Constitution was sufficiently flexible to allow the President to take the necessary constitutional action.
Bless you.
Well, since we're at the Wilson Center, I do want to say a few words about President Wilson. We're often reminded, as Sonia mentioned, that he's the only president to hold a Ph.D. and came to the presidency having served as president of Princeton University and having published a classic treatise, actually twice, on American government and served as one of the foremost political scientists of his time. He was a proponent of close executive legislative partnership in domestic policy and a strong independent executive in foreign policy. The issue of balancing liberty and security in times of crisis arose for Wilson in his administration's efforts to build support for America's participation in World War I. As Sonia mentioned, pre-presidency, he made strong statements in support of uninhibited debate and dissent on governmental matters, and after he became president and faced World War I, he was a proponent of suppressing such dissent and such speech. He did so through the Espionage Act of 1917. His Department of Justice, which didn't even exist until after the Civil War, used its considerable resources to prosecute over 2,200 individuals during the war under the Espionage Act for allegedly disloyal, seditious, or incendiary speech. Nearly half were convicted, and many received substantial prison sentences. An initially skeptical Congress went along with the legislation, and the courts, including the Supreme Court, became a partner with the Justice Department in the punishment of political speech. As for executive constitutionalism, the book concludes at 62 and 63 as follows. The Wilson experience is a cautionary tale. Although the President and Congress together formulated a plan to address a perceived wartime security need, their cooperation did not guarantee that an appropriate balance had been struck between security and liberty. The historical judgment is that enforcement of the Espionage Act caused unnecessary deprivation of civil liberties. Perhaps a more emboldened Supreme Court could have limited the infringement, but the cases reached the court after the war had ended. It took these cases and backlash against heavy-handed repression under the Espionage and Sedition Acts for the court to begin to find its footing in the development of more robust First Amendment doctrine, something that Flip knows a great deal about and probably a great deal more about than I do. I don't want to take too much time before getting to discussion, so I'm not going to talk at this point about Roosevelt and Truman. If you'd like, we can take that up in the question and answer session. But I'd like to move for the final part of my remarks to the third part of the book, and I'll be brief here as well. But of course, the third part focuses in detail on the Bush administration's policies to address terrorism in the years following the September 11 attacks. It provides detailed analysis of the torture, surveillance, and detention issues, including the unilateral formation of military commissions. We'll have time to talk about all of these issues, but let me just say a few words about detention. The detention issues after 9/11, as we all know, probably drew the most intense and sustained political and legal attention in striking the liberty-security balance during the Bush administration. Congress did not effectively check the executive in any of these areas, torture, surveillance, and detention, but the Supreme Court drew the line on detention and military commissions. In cases decided in 2004, 2006, and 2008, the court said the president had exceeded his authority in denying some form of court review of the legality of confinement for the Guantanamo detainees, and that the president had exceeded his authority when he unilaterally established military tribunals. The book analyzes these Supreme Court decisions in detail and describes how they prompted Bush to go to Congress for help. Suffice it to say that the sequence was unilateral executive action on detention, followed by Supreme Court rejection of executive power, followed by some successful attempts by the president to convince Congress to let him do what he previously had tried to do unilaterally. A quick excerpt on that, and then we will wrap it up.
Page
147.
Perfect.
The president's uncompromising assertion of unilateral executive authority on the detention issues denied the nation the benefit of its politically accountable branches reaching timely agreement on how best to proceed on these difficult questions. As a practical matter, these constitutional disputes delayed the effective resolution of the status and adjudication of the detainees. The president's intransigence, supported by legal opinions of executive branch lawyers, produced deprivation of due process. The executive's extra-constitutionalism failed to advance the national security results the president was aiming to achieve because, at the very least, his unilateral actions and subsequent need to seek legislative support significantly delayed resolution of a host of detainee issues that continue to fester to this day. Well, that's a very quick gallop through the three major parts of the book, skipping over parts that if you've written the book, you hate to skip over, but for those who are listening, you're probably happy I did. But I'll just give you one last concluding remark and then turn things over to Harvey. This from the conclusion. The intersection of separation of powers and individual rights calls for each of the branches to play important and distinctive roles. Because the executive is designed to act more promptly and decisively on national security matters than Congress or the courts, the president occupies a constitutionally strategic position to determine the security and liberty balance. When the president falls short on sharing responsibility with Congress and on safeguarding individual rights, corrective checks and balances through legislative action or judicial review do not necessarily occur in time to prevent deprivations. Much, therefore, falls on the president's shoulders to redeem the purpose and promise of constitutionalism. Rule of law constraints through legislation and judicial review are important and necessary, but not sufficient. The nation must rely on the president's ability to make sound decisions based on a commitment to constitutionalism. And with that, I'll conclude my introductory remarks, and I'd just like to say how delighted I am to be joined by Harvey Rishikoff today. Our paths have crossed in a very different context in the past. We were both law school deans at one point in our careers, and I think we're both probably a little happier to be here today rather than to be in the fundraising business. So, Harvey, let me turn it over to you.
Thanks so much, Scott. Well, Scott, we first met because we were in, we call it Dean's Baby School. When you become a dean, you're sent by the ABA altogether to figure out why you took the job. As one of my favorite partners once said, being a law school dean is very much like being a short individual wearing red with a large sort of dogs who have bladder problems, which you understand is your faculty. So the issue becomes for me, in full disclosure, is that I've also known Sonia for almost 30 years. I know many of you think we were red diaper babies together. I don't know you know what that means, but that we met at Harvard many, many years ago. So I think it's wonderful that Woodrow Wilson has actually decided to make Sonia run the center. It's a really inspired, brilliant choice to follow a brilliant, inspired leader who was leading it for so many years. My relationship with the Institute goes, at one point I was with the Chief Justice, and the Chief Justice, is Chancellor of the Smithsonian, which Woodrow Wilson is part of, which he's focused a lot of time on as being one of the intellectual centers of Washington. And I think under the leadership of the last number of years has demonstrated how important this institution plays inside the dialogue that takes place inside Washington. And I think it's a great honor to be part of this group being able to do this. I noticed that I have one of the individuals in the room is one of my editors who's actually edited me on a piece on Waldheim, which sort of deals with the Civil War cases, so I'll be particularly clear and crisp with him sitting there. I will do the following. How many of you have actually read the book? Okay. How many of you are from Princeton who actually have a degree from Princeton? Excellent. Okay, so demonstrates an interesting correlation. The riddle that Scott has sort of chosen for himself is security with liberty. That's sort of the issue that is at forefront of what we're dealing with. And he has written a very shrewd, clever book. His answer to the riddle is something called executive constitutionalism. And it's really only defined, it's mentioned a number of times through the book, but on page 31, when you get your copy, he has the clearest sort of definition, and he says it as follows. Executive constitutionalism means accountability to the Constitution and the people by basing government action as much as possible on the broadest basis of legitimacy, executive action authorized by Congress. It means shaping major decisions with Congress and welcoming congressional oversight and direction. It means welcoming judicial review and respecting the judiciary and the constitutional tradition of due process. Actions that attempt to avoid judicial review of executive action, including support for legislative proposals to strip federal courts of jurisdiction to review constitutional challenges, undermine the credibility of executive constitutional. Finally, it means implementing processes inside the executive branch that facilitate effective executive action within the law. Presidents should hold their ground within the separated powers framework, but they also should accept the checks and balances that go with it. I think that is, in a nutshell, the argument that he's putting forward for understanding the way the president should approach the problem. Now, in that context, the book is framed because the five cases, all deal with questions of emergency. So the question is, when the president is confronted with emergency, what is the appropriate method or process he or she should follow? Now, the defense that presidents have always used in one variant or another inside the five cases is usually necessity. It's usually a military necessity defense that is used when you go outside of the system. Now, intriguingly, at the beginning of the book, Scott makes the point that there is no Lockean prerogative. How many of you remember your Locke? To refresh your memory, his argument, which appears on page 27, is that if you look at the document, there's only one area of the document he contends where you see a Lockean prerogative. And that's, of course, the suspension of the habeas. But intriguingly, that Lockean prerogative appears in Article 1, not Article 2. So the argument would be is that the Lockean prerogative is vested or a part in the Congress, not in the president, which gives the argument that if you are going to move towards a form of restricting of rights, that apparently Congress must be directly involved, which is an intriguing way of looking at the document, and it's an intriguing way of saying how the framers framed the document, because comparatively, when you look at other constitutional designs, where you see the power of an executive branch to suspend liberties or rights, the British call it POGG, peace, order, and good government, When they exercise peace, order, and good government, they basically suspend the British Constitution and they move forward in order to create order. The French, of course, used the famous phrase raison d'etat, for reasons of state, that the great democracies all have some residual understanding of a need to suspend rights. And then the question is, what triggers that moment? How far can you go in the suspension of the rights becomes the issue, and what does that mean? Now, sprinkled to the whole book are quotes usually from Brandeis or Frankfurter. When in this area of the law, it's extraordinary how often Brandeis and Frankfurter are sort of the leading proponents of the gems that lawyers kind of till. The key argument for the Brandesian quote, which he ends very close to the end of the book on page 159, he talks about the separation of powers was not to promote efficiency, but was to preclude the exercise of arbitrary power. That is sort of the heart. It's in the Myers case that Brandeis uses it. So what's intriguing about that is that there's a recognition that under normal times you have a separation of powers, but when there are extraordinary times and you need efficiency, how does the efficiency cabin? What is the mechanism that you cabinet? He has his 5 cases, and then he uses, which he didn't mention today, but it's really an intriguing classic law professor way of thinking about the problem. And I mean that in the most positive way. He lays out the prisons, which is executive supremacy, which I think arguably is how he sees the Bush administration, believing that they were supreme in this moment and that they were functioning under that authority. I think to understand the Bush administration, you have to understand that so many of the theoreticians were born out of Iran-Contra. So Addington is the man who writes the Minority Report, opposing the, quote, criminalization of political differences. He writes it for a then young congressman named Dick Cheney. Their perspective, oh yeah, by the way, everything I say is non-attribution in the sense that I am a part of the National War College, but I'm here on my own behalf. I am not speaking on behalf of the current Secretary of Defense or the executive branch. Let me go back to my remarks. The issue is that they believe that the presidency, the office had been diminished. And they were coming to power to exercise and expand that power of the office of the presidency. You see it systematically in cases that they take vis-a-vis not wanting to give up information vis-a-vis who the president meets with. There's a very conscious, I think, analytical approach they're taking. And they're arguing that one has to understand that over the last number of years, the power has shifted in a way outside of that office, and that's not a proper constitutional balance. I think that's part of their philosophical way of understanding this issue. The second prism is political branch partnership. And the political branch partnership issue is that how does the executive perceive its relationship with the Congress? Now, ironically, in the case of Wilson, how ironic to be in the Wilson Center, but Scott argues that the originally, of course, is the Espionage Act of 1917, but then there's the Sedition Act of 1918, which goes even farther. So the argument there is that here you have a president that's being actually egged on by the Congress vis-a-vis its desire to go after what it believes are improper activity. So it's an intriguing sort of problem inside his model. The second issue is judicial review. And here on judicial review, I think the book is particularly intriguing, and here's why. Because the model that underscores the cases is following. And Scott didn't read it, but it's sort of weaved through the book. And this is the model. The model is that you have a crisis. And when you have a crisis, there's a tendency that the executive will become active, which is natural because the people are holding the executive responsible and they're looking to the executive to respond. But he says in these moments, more often than not, you have a weak Congress that gets caught up in the moment. And I would argue that we had a very weak Congress during the period of time of the Bush administration, that when the Republicans were in power and controlling it, they were loath to go after the president vis-a-vis activity. It changed a bit when power shifts in the Senate, and you can see more of the separation of powers. But most intriguingly, for us lawyers, is he's also, in this narrative that Scott weaves, he's extremely critical of an ineffective judiciary. He argues that they're usually late, after the fact. They too can get caught up in the fever of the moment, and that they are not really structured to deal with the problems of national security issues. And if you look at the cases that follow his historical cases, the court often refers to them as some of the great self-inflicted wounds. So the case law that we are not proud of, that the Supreme Court has participated in, the Korematsu case, for instance, vis-a-vis Roosevelt. And in that case, he teases out the three famous cases, which is the Hirabashi case, which deals with the curfews, the Korematsu case, which deals with evacuations, and then the Endo case, which deals with detentions. But it's a court failure case. We look to the court to be the counterweight, and sometimes it is not the counterweight. It's a court failure moment. In the Lincoln moment, you also have a court success moment, but Lincoln refuses to abide by the law, and he goes to Congress. So it's another interplay in which it appears the court did the right thing, but the executive branch chooses to not abide by the decision, but to go and ask for, after the fact, a legitimization of their activity. In the Roosevelt case, you have basically another court failure, because under the you have the Japanese case, and then more importantly, if you remember, it turns out when the historical record became clear, it appears that there were serious misrepresentations made by the military to the Department of Justice and to the executive branch, and the Department of Justice is a little unclear what their role was. And that's why years later we had the restitution to the Japanese in turn. And part of the reason, I think, is not because there wasn't the sense that the power was appropriate for the executive to do that. It turns out that the amount of misrepresentation that took place becomes part of this ugly story that is the self-inflicted wound. In the Truman case, the court is a hero again. And it's a hero because that's the other case that, again, it's a Jackson quote. Everyone who teaches national security law has to use the Steele Caesar case and the continuum that Jackson set up, which works its way through the entire book. So when the president acts with the authority of Congress, he's at the highest degree of his power. When he acts in which Congress is silent, it's the zone of twilight, known as the twilight zone. And then when he acts when the Congress has filled the space, and he believes has filled the space unconstitutionally, that's when it's the lowest ebb. But then someone has to determine whether or not the executive is correct in its assessment. The perfect example of that in the case of the Bush issue is over the surveillance issues. Because in that case, and Scott mentions it, but sort of more of a footnote, because I think it happened later as the research was going, there was a Court of Appeals case concerning the surveillance court in which the court implies in dicta, a case written by Judge Silberman, in which he says that he believes in the dicta that the president had residual power and that parts of the FISA Act may be unconstitutional. So there was a thread of legal analysis that the administration was using when it pursued its, quote, warrantless campaign. It was standing on a threshold of a case, and that was the case that talked about the primary versus significant purpose, which Scott goes into. But the point I'm trying to make is it's not a great moment for the court. But the three great moments for the court in the Bush case are the trilogy of Rasool and Hamdan, then Hamdi, and then Boumediene. There the court appears to be acting in a manner that is pushing the administration and the Congress to perform its constitutional duties. So it's a mixed message vis-a-vis what the role of the court is in his narrative. The next prism is retroactive judgment, which is when you go to the Congress to be able to put a bomb over the activities that have taken place. Because not many presidents do that, but Lincoln in particular was famous for having done it. And then there's the prism of extra-constitutionalism. And that sort of is married to the issue or prism of executive supremacy. It's what one man's executive supremacy is another man's extra-constitutionalism. And you have to discern, and I sort of in the debate, it'll be intriguing to ask Scott why he thought it was very important to add that prism and how he sees them being so different and distinct. And then finally, he has his view, which is executive constitutionalism, which I read the quote. So, staying within my time limit, I have 6 questions. I'm a student of Stanley Hoffman, so everything has to be a multiple of 3. The first is, in this debate in the modern world, the first threshold question is one has to decide, is the global war on terrorism or the struggle against violent extremism different from other emergencies? Because on page 86, Scott says that the emergencies reviewed in the previous chapter, which are all the cases, were all perceived at the time as temporary despite unpredictable endpoints. By contrast, the war on terror is forecast as a chronic state of affairs. Moreover, unlike the uniform military conflicts contemplated in the laws of war, the war on terror confronts a stateless and widely dispersed enemy that is difficult to identify and committed to causing civilian death and destruction to achieve its aims. Although the nature and scope of the war on terror will vary over time, the relative permanence of the crisis will correspond to the emergency powers that are claimed to address it. The constitutional and democratic challenge is for the political branches to formulate security policy together to meet this threat. The Bush administration did not see it this way. But what Scott is saying is that he thinks that there's something different. So given that it's something different, what is the appropriate rules to craft? You can argue that you need all the parts of the Constitution involved, but what are going to be the concrete rules? Because where is there residual inherent power implied in the executive? And what's also part of the narrative that's behind the book is we do have the 1947 National Security Act. So there's the whole world of covert action. And covert action gives the president extraordinary power. It's, I think, part of the Lockean prerogative is actually where you might see the 1947 Act. It's not in the Constitution, but in the statute. And as you know, we have a controversy right now because the argument is that members of Congress were briefed about a certain number of the actions and programs, but yet it's unclear what was said, when it was said, who was there, and what you're supposed to do once you're briefed. So it's an intriguing element. So another question is how you see the covert action, which is covert in the book, but yet a large part of the issues. Then the second question is, has constitutional history created the Lockean prerogative? That you argue it's not in the Constitution, but when you add up all of the actions taken by these presidents, can a new president come and say, well, there is extraordinary precedent of presidents doing this, therefore that must be a form of power. There also is an interesting analysis of Justice Douglas and Justice Jackson on page 72 and 74. And for those who are interested in sort of the legal jurisprudential questions, Scott takes to task the Justice Douglas. And what he says about Justice Douglas, he says, Justice Douglas, concurring in Hirabayashi, said that, quote, military decisions must be made without the benefit of hindsight. The order must be judged as of the date when the decision to issue then was made, period. This is Scott. But surely this cannot be correct. One of the advantages of judicial review is that it can use the calm perspective of hindsight to assess the constitutionality of government action and give direction for the future. So one of the interesting jurisprudential questions is, when you review these issues, should you review these issues from understanding what the decision maker understood at the time vis-a-vis their balancing of crisis versus activity? Or are you supposed to use a different standard after the fact and then evaluate political actors and operators? It's an intriguing, real hard question, and I'll explain to you why. Then the other issue that I think would be interesting to hear Scott talk about is, he mentions the 9/11 report on page 106. And there he asserts that in the 9/11 report, there's a recognition by the commissioners that there are moments when power must be asserted by the government. And he says there's sort of a test for when you assert that power. And the test should be, the burden of proof for retaining a particular government power should be on the executive to explain, A, that the power actually materially advances society, and B, that there is adequate supervision of the executive's use of power to ensure the protection of civil liberties. If the power is granted, there must be adequate guidelines and oversight to properly confine its use. And there, to me, the issue is, in these concrete, hard moments, when you assert your power, as long as you say you have oversight, is that sufficient? Because we've had decades now of oversight in the Church and Pike Committee at HPSCI and SISI, it's the House Permanent Intelligence Select Committee, and the Senate Select Committee on Intelligence, and yet we've confronted a bit of a constitutional problem, because the senators in these, and congressmen in these committees are saying, we are briefed, but it's unclear what we do with the briefings. So we've created a very bizarre sort of world in which there is informing the Congress, but Congress appears it's unclear what they can do. So I'd be interested in Scott's final sort of thoughts about that. And then I have two last points right within the 20 minutes. The first is, given Scott's analysis, what is the responsibility then on the attorneys inside the national security enterprise vis-a-vis their advice that they give, the analysis that they give? How are they to be held accountable? As you know, there's quite a controversy now concerning the Bush attorneys vis-a-vis their interpretations of statutory law and international law, and that the president followed, apparently, these interpretations. So that whole issue of the ethical world, particularly in the Wilson Center, the ethical problem for attorneys and operators giving interpretations of their understanding of the Lockean prerogative vis-a-vis what they're confronting, I'm curious to hear what you have to say. And my last point is, because, as a professor, last point is on page 15, you say there are only a finite number of ways to remove the president. You can say there's death, resignation, the two-term limit, defeat at the polls, or impeachment. And I encourage you in the next edition to visit the 25th Amendment, right, which says that when the vice president and the cabinet decide that the president cannot fulfill his duties, he can be removed. Some argued that might have happened in the Bush administration, but we have no equivalent amendment for the vice presidency. So as a result, it's an interesting moment in executive power as to the role of the executive, and when the cabinet feels the president has gone off the rails vis-a-vis a variety of incapacities. It's always the stuff of movies. You began with the movie, and that's a very popular movie theme. But my students are always intrigued by that. Vis-a-vis, is that an interesting way? You have to be very careful who you appoint in your cabinet. So with that, I will turn it over to you and questions.
Great. Thank you for both the presentation and the comments. I never thought I'd actually think it would be fun to go to law school, but I'm beginning to think it's probably a very lively place to be these days. Scott, would you like to respond, or should we open it up?
Well, maybe I'll take a stab at one, but
Okay.
not all, because we've got
Sure.
to give other people an opportunity. Good point on the 25th. I'll remember that one. And maybe I'll just start with the first point that Harvey made. And by the way, great comments, and thanks so much for reading the book so closely, and very helpful. And as I was listening, I wish I'd had a conversation with you as I was writing it. But
You will in the future.
It will. It would have been a better product for having done that. But thank you very much. I think that will get us going. Harvey's first point had to do with, or first question had to do with whether we're dealing with something of a different kind in the war on terror as opposed to the other examples given in the book. And as indicated from what he read, I think that we are dealing with something different in kind in dealing with these issues, because in all the other examples, and I take Lincoln as a prime example, he was insistent. He repeated over and over again that many of the actions that he had taken during those fateful 12 weeks and beyond, especially as they related to individual freedoms, were temporary, that when the war ended, the actions would end. And he kept reminding the public that that was the case. What we have now is a situation where President Bush reminded us over and over again, and for that matter, President Obama has done so as well, is that we continue to be in a war with terrorism, and it's a war with seemingly no end. It's a constant condition, and when phrased in that way, how we address some of the issues that are raised in the book take on a different perspective. Harvey mentioned the National Security Act of 1947. I think there are many commentators, and I would include myself within the group, that it is far past time to take a comprehensive look at the national security framework legislation that we have, and that we look at it from the standpoint of how to address the circumstances we find ourselves in. While it's true that when a president is facing an exigent circumstance, the executive is both responsible and as a practical matter must be the first responder and to take action to deal with the situation. But when we're dealing with chronic situation, as we have been for some time now, the time and the opportunity is there for a thoughtful interbranch dialogue and the normal processes of constitutional democracy to address these challenges at hand. And so I would say that framework legislation would be one of my answers to that initial question. And framework legislation that would also help guide response to the extent it can be drafted, even in exigent circumstances. It's very difficult to do and can only be done up to a certain point. But I think I'll stop there in response to question number one and maybe open things up for others to raise points or ask for responses to other questions.
Okay. Flip, I'll give you the honor of the first question. And please introduce yourselves.
Philippa Strum, Wilson Center. Thank you so much. That was really very, very stimulating, and I found it very depressing because it sounds to me as if the conclusion is, in the end, checks and balances are neither a sufficient check nor sufficient balance, particularly as you talk about the unwillingness of Congress to assert itself at moments in emergency, which leads me to my question. In a way, I thought it was kind of an inside-the-beltway discussion, or maybe an inside-the-law professor's discussion, I'm not sure, simply because there are two institutions, if we might call them that, that you might want to comment about, and I didn't hear you comment about. One is the public, and the second is the media. And certainly, I would suggest that in all of the situations, Congress was not more assertive, or has not been more assertive, out of a feeling that that's what the public wanted, that the public would support the president's extra-constitutionalism, whatever, anti-constitutionalism, whatever you call it. And the media, in all of those situations, as far as I know, I don't know about the media during the Civil War, but I do know about the media during the other situations, media was not performing what might be considered its function as well. So how does that play into the interplay among all of those institutions?
Well, I knew I could count on Flip to ask the tough question. Well, I'll give it a try, but let me start with the media in terms of the Bush policies that are addressed in the book. It was interesting in looking at the torture, surveillance, and detention issues from the standpoint of how the press covered them and how the press reported on them. It actually was the press that performed the checking function on the surveillance issue. As you'll recall, in December 2005, the New York Times reported on the terrorist surveillance program, as the administration was calling it, and had held the story, actually, for the better part of the year at the administration's request, and finally reached the point that it was going to go ahead and publish, and the president himself made a personal appeal to the Times not to report. The Times did, and it was the revelation of the warrantless wiretapping program through the press that brought this to the attention of the public, and for that matter, to much of the Congress. There had been, as they referred to them, the Gang of Eight at Congress who had been briefed on the program, but the Congress acts as a whole and as an institution, and it was really aggressive press reporting that brought the surveillance program to the public eye and to a large extent to Congress. Interestingly enough, despite outcry over what had happened, it took until the summer of 2007 before there was significant legislation on this issue. So I think the press was actually ahead of the Congress, maybe not so much once it was reported ahead of the public, and it's noteworthy that Congress did not act until after the composition of the Congress changed over in 2006, but that when it did act, it gave the administration much of what it had asked for by way of corrective legislation, interestingly enough. On the torture front, the revelations of Abu Ghraib and the leaking of the infamous August 1, 2002 torture memo also came through the press. So the press played a role there. And although it's discussed in the book, I take your question to heart that maybe from an institutional standpoint, some more emphasis on press performance and the role relative to the interaction of the branches would be a healthy addition to the analysis. But I think that the press was there, maybe not to the extent that we've seen it in other contexts.
So the revelation of the rendition issue becomes quite powerful. And then on the press issue, it's only much later do we realize, and it's made public, that the waterboarding is not a single instance but 183 instances for KSM. So my sense is the press has been, in this over the last 8 years, has played a rather sort of checkered role inside the debate about national security. It also, you allude to it in the book, but you say you don't write it because there's, how long can the book be, is that the issue of state secrets. So the state secrets in the Reynolds cases have been the classic way in which the government asserts its authority to keep the press out. And then I think it's if you want another program, which would be fascinating, another program fascinating is how the press sees its ethics vis-a-vis being Americans and also being a member of the media profession. So in the military, we always ask the question to an American journalist, if you could get an exclusive interview with Osama bin Laden, would you tell authorities his location? Would you believe that's a violation of your professional ethics or as an American, do you think that's appropriate that you do that? And you'd be stunned to hear the range of answers that the press gives inside this national security dilemma. And for the public issue, I think the public has been extraordinarily absent in the debate for national security issues. I don't know if you know, there was a recent poll done by the American military about whether or not torture should be done. And the vast majority of American soldiers, I think a certain significance, said, yeah, of course you should. So I'm so curious what the public is. Which is the relevant public anymore for the debate the way it's been carved out over the last 8 years. And as you know, the new generation, my kids are tweeters, and I'm a tater apparently. If you hate tweeting, you're a hater.
Tater?
I'm a tater. I'm a hater of the tweeter. So that notion of how we understand information in public has also gone through a reformation, and it doesn't lend itself well to national security reasoned discussion, which is why I think it's great that the Wilson Center is doing this, because the more there are debates that get this out among the individuals, the more you have a way of having an informed discussion. But how that really translates to the public it's unclear to me. And also how it translates to the media is unclear to me, because I could probably say that there's maybe 10 reporters inside the country who really do national security law for the main periodicals. And we used to say when I was in the government, there are only 2 national papers anyways. Do you know the 2 national papers are? It's the Wall Street Journal and USA Today, because the New York Times actually is not read that much outside of in hard copy. Now we can get it on our BlackBerries, and that's created a greater review of getting information out. But I think it's a very interesting question as to concretely between the media, how hard they understand these issues and what they think is exposure, and then how the public really responds to it.
Yes, please.
Hello, Harvey.
This is my editor.
Melvin Urofsky, Virginia Commonwealth University. I would like to explore a different scenario regarding Lincoln, because the one that Scott and to some extent Harvey put out is not necessarily accepted by all historians. That is, Lincoln comes in, takes the oath of office, and essentially runs a one-man government until July 4th of 1861, when the Congress meets and ratifies ex post facto. I hate to say it, but it's been almost a half century since I was in graduate school, and Eric McKittrick put forward a different scenario, which I think makes it the constitutional aspects are changed, and that is, not only did the Republicans win the presidency in 1860, they also won the Congress. So the new Congress that was going to come together on July 4th was dominated by Republicans in both houses. The leaders of those houses were in Washington during that entire spring, and that Lincoln consulted with them before taking any action, knowing ahead of time that he wasn't going to go hat in hand to the Congress, and that was in the days of party discipline, so that if the party leaders could tell him, yes, we will approve that, in essence, he knew ahead of time he was going to have congressional approval for what he did. Now, if you take that view, that's a much different constitutional interpretation than a man sitting there running the government by himself without any consultation or approval by Congress for, what'd you say, 12 weeks or whatever the amount of time is. That's a much different scenario, and I'd like you to address that, since that does seem to be what Lincoln did.
Mm-hmm. There's always the Lincoln question when you write these things.
Well, I think that at least the historical record, as I understand it, sees Lincoln as having, yes, operating under both Article I and Article II powers when the Congress was not in session, but also being very confident that when Congress returned, that even though he was exercising authority that would, under normal circumstances, require legislative authorization, that the Congress, once it was back in session, would go along. I think from the standpoint of constitutional analysis, the fact that he was talking to the leadership is a mitigating factor, but does not change the fact that he was spending money that hadn't been appropriated, suspending a writ that because the power to do so is in Article I and requires a legislative determination, he went ahead and did it anyway, still raises the same constitutional issues. But I think that your point is very well taken, and actually speaks well of Lincoln in the sense that he was facing an exigent and severe situation, dealing with it as best he could, and was engaged in the consultation that you described. I think that the debate remains whether he could have brought Congress in, or Congress could have come back sooner, or whether that was stretched out a bit to make it a little easier to implement some of the things that he did. And I think that's really where a lot of the debate at this point has been focused. But I think you make a very good point.
If I could just follow up, I mean, isn't what Professor Urofsky is describing what you recommend as part of executive constitutionalism? When you say, at the end of the last chapter, Scott has a new pledge that he would hope that the Commander-in-Chief would take, and one of the tenets of it is consult with the Congress and seek all necessary and proper legislative authorizations before taking action, if possible, but as soon thereafter as practical. So isn't that sort of what he's describing?
Yes.
In defense of Scott, further now that I feel one with the book now, is that he's really focusing on ex parte merriment. So if you're focusing on ex parte merriment, discussions with the Congress is not going to help you, because he's saying the court's wrong. I do have this authority, and that maybe they'll come back and help me, but I'm not going to appeal to the judiciary. I'm going to do this right through a legislative act, which is the two branch argument. And we all know ex parte merriment stands in the pantheon of cases, as does Valdingham. So I think he's using that in a way to defend him, so he doesn't get mired in the famous Lincoln scholarship debates about what's going on. That's what I think is an answer that you may have.
Don?
This is all pro bono, Scott, by the way.
I'm Don Wolfensberger with the Congress Project here at the Wilson Center. I enjoyed your presentation, also the commentary immensely. At first, I think I misunderstood you in saying that Congress had done nothing after 9/11. The courts eventually weighed in on the detention issue and so on, but then you clarified, I think, with Flip, that eventually the Congress did come back and do something with regard to the FISA Act, certainly, and they did something on torture, too, which I don't believe you mentioned, but that the President did sign that into law. He did have a signing statement, of course, that some people took umbrage at, but you didn't mention the Patriot Act, which was, he did go to the Congress for that at the outset. Congress did trim back on some of the more ambitious requests that the Justice Department had. The Congress did put a sunset date on that. They have since renewed it and since revised it further. So I'm just wondering if you're selling Congress a little bit short under the circumstances. But then also thinking of Truman, I'm sort of tying in two questions together. I'm wondering why you seized on the steel seizure case and not on some of the other issues related to that. I know you're not writing on war power, so we won't go into the fact that Truman didn't seek a declaration of war, whereas Bush 1 and 2 did. 2 did it twice. In effect, the authorization for use of force is equivalent of a declaration of war, as the Supreme Court has indicated. But why did you focus on that as opposed to some of the other things that were going on at the same time during Truman's administration? Granted, Congress passed the Smith Act and other things, but there's a lot going on with regard to individual liberties. Do you go into those things as well, and how the administration responded to these laws that Congress was passing, cracking down on communists?
Okay, thank you, Don. Let me start with your first question about the Patriot Act. As you all recall, shortly after 9/11, very shortly after 9/11, Congress passed the Patriot Act and the authorization for the use of military force, and in fact did not go quite as far as the administration wanted on either, although the differences were not all that great. This was at a time when we were feeling the most severe threat in the immediate aftermath, and Congress was very supportive of the president and was more than willing to go along with what the president wanted to do in that legislation. And the administration has really seized upon the authorization for the use of military force, the AUMF, to justify all manner of things that they were trying to do during this period of time. And in fact, I think that the Patriot Act and the AUMF, in a way, almost reinforce a basic point about the book insofar as the relationship between the administration and Congress. And it's this: why in the world didn't the administration, having such a supportive Congress, two-party control of the two branches, immediate aftermath of 9/11, seek to work with the Congress on the issue, for example, of surveillance? If we were in a situation where we were structurally and technically not up to speed in terms of our current laws on that issue, why set up a separate and secret program when you've got a Congress that's pretty much giving you everything you want anyway? And my answer to that is that there was, within the administration, in the form of the small legal team that was advising on this, a strong commitment to making the executive power point. And I think that that's one of the reasons that this happened. Once Jay Bybee and John Yoo vacated the Office of Legal Counsel, and you had Jack Goldsmith come in, whose politics and his views on executive power were sympathetic to the administration, he starts looking at the secret torture memos, the memos on surveillance, and has written a book on this in which he writes very clearly. He was mystified as to why Bush, the administration, wasn't working more closely with Congress on these issues, all of these issues, surveillance, torture, and detention. So in a way, maybe the emphasis, Don, goes back to the administration not wanting to engage and consult, interact, and problem solve on issues where there was a willing partner, especially pre-2006 election. Having said that, once the surveillance and torture information, Abu Ghraib, the warrantless wiretapping program, was revealed, there were certainly hearings, strong statements coming from the Congress. There was legislation in the form of the Detainee Treatment Act of 2005, where Senator McCain inserted an anti-torture provision, but there wasn't the kind of legislative response that seemed to correspond to the kinds of revelations that were coming out in the form of comprehensive legislation and consultation. But I put that more on the administration side of failing to take more proactive action. It was only after some of these Supreme Court decisions involving detention where the court indicated that the detainees were entitled to habeas corpus review. If they were citizens, they were entitled to due process review, that the military commissions were unconstitutional. It was only then that the administration was really forced to work with the Congress on these issues. So I take the Patriot Act and the AUMF, and I think, well, if the administration can get that kind of support on measures like that, why weren't they there front and center on these other things? And their own attorneys who came in later had the same question. Very quickly on Truman, you're quite right. There were other examples during Truman. There were examples during other presidents' administrations that would be pertinent to the analysis in this book. I chose to focus on the Steele seizure in part because the Supreme Court decision in that case set the analytical framework for separation of powers that courts and others have relied upon so much through the years, and that I relied upon as a framework for the other historical periods mentioned in the book. So that was really a strategic choice on my part to focus on that case.
Just following up on one thing, though, keep in mind that President did not control all of Congress in 2001, 2002. The Senate went Democrat in June, and so you had the President working with Democrats on the Patriot Act, the use of force, but I think they were reluctant to push further, knowing that the Democrats would only go so far, but they really controlled things for a year and a half there.
With the Jeffords. That's right. The Republicans did not. The expert is absolutely in the room here on the Congress, and although there was Republican control for most of that time, in those years, you're quite right. On the other hand, in the immediate aftermath of 9/11, it did seem that Congress was ripe for supporting security measures proposed by the administration.
Just on a footnote, though, when you start teasing it in a technical way, the Patriot Act change on the FISA court from a primary purpose to significant purpose, for those who in our field, that's a huge, huge change, which makes the Congress appear to be part of the fever vis-a-vis what's taking place and how that type of covert action is going to take place. And rather than being, many people in the law enforcement community did not see the need for that change, but it was perceived as being the wall issue, and it's unclear to this day among many people who were there at that time whether that was the true issue that stopped the information from being passed. On the second issue is on the Detainee Treatment Act, the Congress very clearly makes it applicable to the military, but not to the non-military, which becomes a bit of a problem the way it's perceived. And the Congress is very clear that they're being told one way or other how you're going to write it. And on the Goldsmith part, which I think is sort of intriguing, is he's written a recent piece which says there's not much difference really between the Obama administration and the Bush administration vis-a-vis their assertion of how they understand executive authority. So even on the habeas issue of Boumediene, that's applicable to Guantanamo, but will not be applicable to Bagram. The administration's position is it should not be applicable to what's going on in Afghanistan. On the issue of targeted killing, the new administration is taking even a more aggressive approach to targeted killing than the previous vis-a-vis what's going on in Pakistan and the Fatah areas. So to me, it's more Scott's point that, and on state secrets, the administration has asserted again a very robust state secrets position. In its filing on Guantanamo, it asserted the AUMF, the Authorization of Military Force, for its authority. There's something very inherent about the executive branch pursuing these issues, even with now a Democratic Congress. And of course, the Democratic Congress just rejected the president's request for money to close Guantanamo because there's, quote, not enough a plan. So it's a very interesting, he tried to work and then has been rejected. So it's almost following Scott's pledge, and yet it's being pushed back. And the question is, what exactly is going on in the understanding of executive constitutionalism between the interplay? And the court, I think, will continue to be playing its role vis-a-vis its understanding. Because don't forget, the Boumediene only declares unconstitutional Section 7A, which is the habeas part, but the rest of the Military Commission Act is still constitutional. And that's one of the reasons why I think the administration is pursuing a concept of trying to revive that as a process, because it's been stamped, approved constitutionally by the Supreme Court. So that it's a much more nuanced, I think, issue vis-a-vis what's going on. But I don't know, I guess my question to you would be, do you think Congress really covered itself with glory during these eight years?
Has it ever?
Well, actually, I wanted to follow up. I had a question that sort of follows on what Harvey just said. And that follows up on the second question that you posed to Scott. And when you said, since constitutional history has created a Lockean, I think this is what you said, created a Lockean prerogative, is any new president entitled to it? I mean, I guess another way of putting it would be, can you put the genie back in the bottle once it's out? So, Scott, I wonder, well, both of you, what you might think about that.
Well, I think I would resist that notion. I think Justice Jackson may have put it best, that if, and I'm just paraphrasing, but he said at one point that if you recognize an emergency to ignore the Constitution, that will just kindle more emergencies. And I think it's a healthy attribute of our Constitution that we don't have a general suspension clause. Harvey pointed out that there have been other Western democracies that have had such provisions. And I think that the absence of one sets up a very healthy tension in our system under which a president faced with impossibly difficult decisions nonetheless has to keep the issues that we're talking about in mind in the course of making those decisions. In other words, there isn't a free pass, and that the limited suspension provision that is in the document, it continues to be a contested issue, even though it appears in Article 1, and many would say that it's Congress's power. Lincoln did make a powerful case that in the absence of Congress, there's a power there, and in the situation he found himself in, he felt that he was acting in good faith constitutionally. But that is not a suspension of the Constitution, and it's the reason I think when the framers established an executive, decided not to have such a broad-based lock-in provision. There was some real concern about what this new office, what this president, what this executive branch might do. Now, there have been presidents, of course, who've taken the open-ended Article 2 language and Bush being, of course, the most recent one, to make rather aggressive claims as to what that means. I don't think I would begrudge presidents the opportunity to make that argument. As I said in the book, I think presidents should stand their ground. We need active, effective, aggressive presidents to keep the nation safe. My argument is that within the separation of powers framework and taking into account the limitations that we've always considered as critical, that it's within that framework that strong executive action should take place.
My sense of, the actual there is the Insurrection Act, which is passed by Congress, which gives the power of the president to act. And then we've set up NORTHCOM, Northern Command, which is a capacity command that we understand is supposed to be able to have surge capacity, which will fall under the authority of the president. Just remember, and the irony of the last 8 years has also been the Bush administration was criticized very heavily for its lack of executive fervor in Katrina. So it's sort of ironic that you have a president who is asserting the power of the executive, but yet seems to delay his asserting his federal authority in a natural disaster. And just after that, Congress did pass, as part of the military appropriations, expansive language for more executive power in the face of crisis. But because it was part of a military appropriation, it only lasts for 2 years, and that was not renewed in the next. Congress did not renew the same language. It curtailed back that sort of opening that it gave to the president. But my sense, we're sort of at a tipping point, because our fear always is that if there is another domestic event that overwhelms local or state authority, the assertion of federal power will be placed on the presidency. And we're all trying to figure out what is the appropriate mechanism by which you have that executive authority exercised. Because we have had martial law in the United States and Hawaii during World War II. And all of us in this sort of field, our nightmare is when you have an overwhelming of domestic capacity, and then the assertion of federal power, if it goes beyond the Guard's power, how we exercise to make sure that things are going to take place in a way that's orderly and civil. And I think that's the fear of the 21st century. I mean, we saw it with the SARS issue. If we would have had a real panic, what would have been the quarantine power of the president of the executive branch. We're seeing it in natural flooding issues around the world. The quote man-made disasters, and then there are natural disasters. I think there's a great deal of sense of looking to the executive branch for solutions. And I think part of the book, which is helpful, is which many of us think we say is, you should not be doing this the first time the disaster hits. We should be exercising and thinking through what authorities are appropriate or not appropriate in order for there to be a reasoned discussion that you argue is the best way for the Republic to think through the problems.
Yes, please.
Donald Barnes, Guangxi University. You've given these examples here, which I think are very good, and I think they're good examples to learn from. How much of a legacy, how much of a shadow is being cast by some of these actions that were taken in the past? I'm thinking specifically about the actions taken by Wilson in the Espionage Act and the Sedition Act, and have now been judged to be not needed at the time, but are they still casting a shadow today?
Well, I think it's important to step back, and when we look at the evolution of protection under the Constitution for speech in this country, and Flip is one of the real experts on this, it was about the time of World War I that the seeds were truly planted for the growth of the doctrinal, judicially enforced protection for speech. In fact, it was around that time where we had the first Supreme Court decision about the scope of the First Amendment protection for punishment, subsequent punishment of speech. And so I think it's important to put your question in that context. And although the initial cases coming out of the Espionage and Sedition Act prosecutions that came to the court all resulted in affirmances of convictions, what you saw coming out of immediate subsequent decisions, the Abrams case, for example, were the famous dissents from Holmes and Brandeis that really set the foundation for First Amendment law to develop. And in fact, if anything, although the court did not push back on the prosecutions and the speech punishments of that particular era, ironically enough, that was the time when modern First Amendment protections started to emerge. So I suppose from an historical standpoint, it's a reminder of what did happen when leadership, the Justice Department, and for that matter, the courts as well, got caught up in wartime hysteria and felt that they were dealing with disloyalty in the name of national security. It's a serious cautionary tale. I happen to think that we've reached a point where the First Amendment traditions that we've now established would protect us from that kind of episode. But we see examples of troubling incidents involving government and speech to this very day, but not in the same way that we were talking about then. I don't know, if, Flip, if that's fair, but okay.
I would have a note of caution. And the note of caution is, let me read to you the authorization for the use of military force. It's the AUMF this is a brief submitted by the current Obama administration with a declaration by the Attorney General Eric Holder. The authorization for the use of military force authorizes the use of military force against those, quote, nations, organizations, or persons the President determines plan, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. This is the first time in our constitutional history that we listed organizations and persons. We've declared war against organizations and persons. Declaring war against a person is the first time we've ever, to my understanding, we've done it. But why that's significant is in the petition for habeas, the government's position is that these habeas petitions should be adjudicated under the following definitional framework. The President has authority to detain persons that the President determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th, paralleling the authorization against military force, and persons who harbored those responsible for those attacks. The President also has authority to detain persons who were part of or substantially supported Taliban or al-Qaeda forces or associated forces that are engaged in hostilities against the United States or its coalitional partners, including any person who committed a belligerent act or has directly supported hostilities, aid of such enemy armed forces. The reason why I think this parallels what happened to Wilson and parallels what happened which is not raised in the book, but the Red Scare, is that what we're saying in this 3 historical times, your status is your crime. Yes, that was your crime. So we're saying if you're al-Qaeda, that's your crime. And the next issue is, what does it mean to support that entity? And then the third issue why this is a very difficult issue for us is that the Europeans have always been very suspicious of our Anglo-Saxon jurisprudence on conspiracy. These are huge conspiracy claims. And what's confronting the current administration, which is a very difficult problem, is what is the relationship of A to the shadowy networks? So what is sufficient enough evidence for us to A, target A, or B, if we choose not to target A, to capture A, and then hold A? That is a very similar analytical problem that Wilson confronted, similar problem that Eisenhower confronted during the Red Scare, and we are confronting that issue. And I will tell you, people in the administration, this is a very difficult thing we're wrestling with, to figure out what is credible evidence. And it raises all of those issues, conspiracy issues, support issues, association issues, which I think there will be extensive litigation that will take place about what's sufficient. Remember we used to say, how do you know if someone is a Joan Baez fan? And the answer was, the military put it to someone who they thought was too liberal during the Vietnam War. And the guy said, I don't know. He says, well, how would you define it? And the answer was, do you have more than 3 records by Joan Baez? And the military said, I have 5. Because well, then you obviously are a fan. So you can't stay on this post. So that level of what is the credible evidence is going to be confronting the American state and the American judiciary and the president and the Congress and judiciary. And it's unclear if they're all going to come to a similar conclusion of what the appropriate. So I think it's very, very relevant, why the book is very intriguing for that, because it lays out the framework, but the devil is in the details when we start to put the actual standards and tests on these issues, which becomes really complicated.
Yeah. I'd just add as a postscript to your question, to the extent that we're worried about a shadow being cast, one of the common threads through the examples in the book, the Wilson example, the Roosevelt example, and the Bush example, are the people who have been targeted, or those who have been most vulnerable to overreaching government action, typically have been those who lack social, economic, political power. And of course, in the most recent post-9/11, we're talking about Muslim and Arab Americans and foreign nationals who've borne the brunt of some of these policies. And so from that standpoint, there are certainly lessons to be learned from what happened during Wilson, when the targets were some of the German nationals in the U.S., the more liberal-leaning critics of the war and that sort of thing. So from that standpoint, I think your question raises a good point.
Over here, please.
Jim Piffner, George Mason University. Would you say a little bit more about FISA and the ways in which it might be seen to be unconstitutional? The administration's arguments just didn't seem very compelling to me.
Well, let me make sure, let me clarify, or ask you to clarify. My analysis in the book speaks mostly to the question of whether the president's program, the terrorist surveillance program that operated independently of FISA, is constitutional. Are you asking about that, or are you asking about the FISA? Okay, but I'll turn that over to you.
Well, what Scott recognizes in the book is that there is an appellate decision. We've only had one appellate decision by the FISA appellate court, in which there is a dicta about what the power of the presidency is inherently in the national security realm. So the example perfectly was, prior to the current legislation which Scott raises about the new National Security Surveillance Act and the Protect America Act, and then the subsequent Congress passing its new Surveillance Act, the technology had gone beyond what the old act had been able to legitimately garner warrants on, because it was an old dialing system, telephones, particular. So one of the big issues in the Patriot Act is we very much in law enforcement had wanted a roving wiretap, that you get a tap on the person, not the number. So that was part of the innovations. And the surveillance issue is, if you are not in the United States and you were talking to someone outside of the United States and you were a U.S. citizen, did you need a FISA? Outside the United States, talking to someone you believe, to another person outside that call, was a FISA required? We all thought no. Now, to Americans, this was shocking, because part of the new legislation said there will be protection for U.S. citizens now outside the United States. The second issue was, because of the way the routing system was, you could have a call between point A and point B outside the United States, but the way they would do it, they may route it back into the States because of the way the packets went. As soon as it touched the United States, we needed a FISA. And we said, wait a second, this is insane, because we know A and B are talking out here, but because of the way the technology is, because it touched the United States, now we have this. So it was saying that cannot be a restriction on the President's Act. The second issue, which is the original FISA had a time limit, which Scott raises, which was, I think you had to get it within 24 hours. You could go up and then retroactively come back after 24 hours. There was an argument that, wait a second, we may need more time. That became, the statute sort of envisioned it. So those were sort of the issues that I think the administration was saying that could not have been meant to be restrictions on the president's power. But the way it was being interpreted was, it is. So they said, no, I think we have the authority to do this because the technology has changed. Subsequently, Congress got involved. Congress has now taken steps. It's expanded and decreased protection simultaneously. Because of the way the technology works, you may want to get a wide breadth of material through the streaming of the packets so that you'll be able to get a search on all that data stream, but you need to get all the data stream. So that's why this issue of the total surveillance program, part of the problem that was behind Poindexter was the image was, the analogy always used by the military is, we used to hunt for Russian submarines. The ocean is quite large. But we figured out technological ways to hunt down those submarines. The same issue in these data streams, our government needed to have a mechanism to be able to get authority and warrants, but go through tons of data. That's what the administration was saying, why the FISA was slowing them down and could not restrict the president, that they had the authority to do it. I think now we're in a debate about whether or not the current FISA legislation is appropriate for what the government wants to do. There's an excellent young Assistant Attorney General, Dave Criss, who's been doing this for a long, long time. And I think if he comes to the conclusion that there may be some legislative fixes, they'll be going to the Congress. But it's going to be worked out. It's the new age in which we're living in. But what they stood on was this decision by the appellate court, which said that there had been restrictions of the on the power inherent in the president. So they stood on something, which was a legal interpretation. That's why I say it's another example of where the law may have failed the courts, because that was not reviewed by the Supreme Court, and that became the governing jurisdictional precedent that they were using to be able to go forward.
Didn't have anything to do with the persons in the United States.
Yeah, it was different, because the person in the United States becomes more complicated because FISA, you have to be an agent of a foreign power. If we can prove you're an agent of a foreign power, then we can go up. It's a probable cause determination, but it's very different than the traditional Title III. I don't know if the Title III issues. So they were saying, no, that standard still remains, because that's when you can sweep up Americans if you believe they're an agent of a foreign power. So that's why.
Yeah, back here.
Could you comment on the constitutionality or the validity of the presidential signing statements?
Well, there was one reference earlier. I think Don mentioned the signing statement in connection with the Detainee Treatment Act, and I'll get to that in just a minute. Signing statements are nothing new. Presidents have used them for a long time. Some used them a lot more than others, and President Bush the most. But other presidents have used them quite often. And the issue doesn't necessarily go to whether a signing statement should or should not be used. The issue really is the content of the signing statement. And under President Bush, the signing statements became more aggressive in terms of assertions of executive authority. And I'll use the Detainee Treatment Act signing statement as an example, because that is one of the famous, or in some circles infamous, of the signing statements. So here's how it worked. As you might recall, Senator McCain insisted that in that legislation, which, among other things, stripped the federal courts of jurisdiction, at least prospectively, to hear statutory habeas corpus petitions from the Guantanamo detainees. Senator McCain, concerned about the torture issue, insisted that for him to support this legislation, there needed to be some anti-torture language in it. And as Harvey described, the language that he was able to get in the bill and push the White House to accept called on the military to adhere to the Army Field Manual for interrogation. So it addressed Defense Department interrogation. That legislation passed. The president signed the legislation, but issued a signing statement that, with reference really to this anti-torture language, said that it would be implemented consistent with the Article II powers of the president. That was immediately read as an escape hatch for the president. If the president decided that because of the needs of the war effort and under his powers as commander-in-chief, he needed to go beyond those restrictions. And that's the kind of signing statement that got controversial. The signing statements, some of which ended up really almost boilerplate because they did enough of them to indicate that, yes, I'm signing this legislation, but to the extent that implementing it would interfere with my Article II powers, I'm still going to, I reserve the right to exercise my Article II powers. It's an issue that, of course, became quite controversial. Hearings on the Hill, the American Bar Association did studies, lots of commentary, and all the rest. I think that that doesn't mean we won't see signing statements in the future. Signing statements serve a real purpose in explaining, for example, why the president is signing a bill, how the president might understand the legislative history behind it, and so forth. Where we get into these choppy constitutional waters is when the signing statement takes the form of, yes, I'm signing this, but I might not comply with it because, as I understand the Constitution, this gets in the way of my doing my job.
But I think the question was, what's the legal standing of it? I mean, does it ever interfere with, does it ever become a legal issue?
Well, it certainly could. It's a legal issue in the sense that it's widely debated in legal circles what the practical impact of a signing statement is or should be. I don't know that we've really had the classic confrontation come up in a major Supreme Court decision, but a lot of constitutional debate and constitutional law isn't discussed, debated, or even resolved within the confines of an Article III court decision. And so the signing statement issue and the debate surrounding it is, we'll have to see how the new administration deals with it and whether the way they do approach it has been shaped by the controversy that has surrounded it during President Bush.
I guess for me the practical issue is from the perspective of an operator, where the signing statements become very difficult and complex. So I think the ABA statement, which is on the website, makes it very clear that it has no constitutional weight. It's the executive just opining about what their interpretation of the statute is vis-a-vis their authority. The real problem becomes, which is how it played out in the administration, is if you have lawyers inside the Department of Justice reinforcing their interpretation of the president's signing statement, saying this is the president's authority, they go to the operator and they say to the FBI agent or to the military, you can do X. And the operator says, well, geez, I thought the reading of the Congress said I can't do that. I'm not a lawyer, but my reading appears to be this is not allowed. And the executive branch says, no, we're the lawyers. We went to the Ivy League schools. We are the federal law clerks. We are telling you that you have the authority to do this. And I think, what law school did you go to, or are you a lawyer? And you have an operator saying, well, geez, now I'm in a bit of a bind because they're relying on a signing statement reinforced by the interpretation by the executive branch's attorneys. So I advise my clients when they're like that is if you think it's wrong, perhaps you should get a pre-pardon for your activity, because it's being done under the color of law with a legal interpretation, and the operator is relying on that particular legal interpretation predicated on a signing statement, predicated on their lawyers interpreting it. That's where you get really dicey, constitutional choppy waters. And then the question is, well, who will you then hold liable for that action? The operator, the attorney, or the president? Because if the president makes a signing statement that clearly flies in the face of what the Constitution, what the Congress does, that's an interesting question of what the Congress's reaction to that will be. And the book deals with cases in which the interpretation of the executive branch, either extra constitutional or it's a supremacy, says we're constitutional actors too. We're having this interpretation. That's when the still seizure case comes in. That's the lowest ebb of your power. Well, that's great constitutionally, but to the operator doesn't say, so you're working at your lowest ebb of your power. Well, that doesn't give me a warm, cuddly feeling vis-a-vis when I follow your directions predicated on that. Where are we? And I think that's the debate being played out now vis-a-vis in the Congress. What is the appropriate way to approach what happened vis-a-vis the investigation of individuals at the agency who were involved in coercive interrogations? How high up did it go? What was the authority? Were they relying on legal opinions? And were those legal opinions based on ultimately the executive branch understanding when it signed the legislation, what it believed its authority it still retained? That's when it becomes very, very awkward, the signing statements.
Or somebody put it succinctly in a movie, who are you going to believe, me or your own lying eyes?
The only thing that's good for Scott and I means you just got to get lawyered up.
Got to get it lawyered up. Okay, I'd like to give Scott a few minutes to conclude and have some final reflections.
Thank you. By the way, Don, I've read an article that Don wrote on signing statements that is very good, and I assume it's still on the Wilson webpage.
Roll call columns, but also Obama issued a March 9th memorandum of his cabinet endorsing signing statements that he used them to carry out his responsibilities under Article 2.
Okay, very good. Thanks, Don. Thanks again for everybody being here. I think it's been a great discussion. I wanted to close just by reminding everyone that what you probably already know, and that it's these issues continue on. And just last week, the President's very important speech, I think, over at the National Archives continues to frame these issues. You'll recall that within a day or two of his taking office, he issued an order prohibiting torture through his administration and to close Guantanamo. In the ensuing weeks and months and leading up to last week, his position on some of these issues has developed further and have become a little more nuanced. And so the realities of closing Guantanamo are such that we're now dealing with, I think he gave us 5 categories of detainees. Those who can be prosecuted in federal court, rather than closing the military commissions, which he suggested at the beginning of the administration, he's now talking about using military commissions for some of the detainees, although with reformed procedures. The other categories include those where a determination has been made that a detainee can be safely returned, but the question is whether a country is willing to accept one of those detainees. I'm going to miss one, but the critical category and the one to look at very, very closely in the weeks ahead. And Obama said this is the hardest problem, and it's the detainees who can't be prosecuted in federal court, can't be prosecuted in military commissions, but nonetheless, in the administration's judgment, pose such a serious threat that they are not in a position to let them go, which means that we're about to embark on a discussion and debate about prolonged detention. And although he didn't give any answers, specific answers last week about what that exactly means, what he did say is that's not a decision that should be made by one person. And it seems to me that that was a critical point, that he's going to engage the Congress on this and the other issues, but especially on this issue, to see if the standards to address this problem can be promulgated in a clear way, that fair procedures can be developed, and that ultimately a constitutionally sufficient answer can be made consistent with national security. So we have an issue front and center that really grows out of our discussion today, and I think it's appropriate to end on a note that there's plenty more discussion to be had, and that this issue is one to follow closely in the weeks and months ahead. So thank you very much, all of you, for coming.